Avila versus Continental Airlines is a California case from 2008 which illustrates a common mistake that many employees make when requesting medical leave or disability leave at work. In that case, the plaintiff was terminated for missing 7 days of work, 4 of which were due to hospitalization for acute pancreatitis. The employee had provided 2 medical forms that only indicated that he was seen for illness or injury and that he was unable to work for a number of days. Avila also stated that he gave the 2 medical notes to his supervisor, but he could not recall if he actually gave those notes to the supervisor directly or left them on that supervisor's desk. After the plaintiff was terminated, he informed his supervisors that he was absent due to pancreatitis, but the employer followed through with that termination anyway. The court found that Avila could not establish that the managers who terminated him knew about his disability because the notes that he provided lacked diagnostic information or other information indicating the nature of the plaintiff's illness or injury, and the plaintiff never told his supervisors about his pancreatitis. The fairness of the Avila court decision is somewhat debatable. Because to me, for example, it sounds like the employee did provide sufficient information for employer to know, or at least has a reason to know and explore further whether that employee needed medical leave or protected disability leave. But it does serve as an important reminder. This case serves as an important reminder regarding several steps that an employee should take in order to avoid being terminated under similar circumstances. First, have a solid proof of delivering your disability or medical leave paperwork to your manager or HR, or preferably both. Simply giving it to them is not enough. They may forget that they received it. They may misplace your documents. Be sure to email and or fax the documents so that you have proof of receipt and so that the employer can never say that they never received the paperwork that you intended to provide. Number 2, don't blindly rely on your doctor to include all the necessary information in your medical note. Your doctor is an expert in medicine. Your doctor is not an expert in workplace compliance with disability laws. Read the note carefully before delivering it to the employer and ask yourself whether it seems sufficient enough and detailed enough to make it crystal clear to your employer what your medical issue is, what your diagnosis is, assuming it should be disclosed, and the fact that you will need medical leave or some other type of accommodation. Ask your doctor to revise your medical note if it appears to be insufficient and if it's necessary. And lastly, it's probably a good idea to err on the side of disclosing more information. I understand that many people are concerned about confidentiality and medical privacy, and it makes a lot of sense. But if your diagnosis is not something to be embarrassed of, if it's a condition that's not going to stigmatize you in any way, why not share it with the employer? Why not help your employer do the right thing?